are a little
don't
bit
frown
off
like
camera.
these.
Good morning. It is 10 a.m. on Thursday, May 8th, and I am calling to order this meeting of the Public Safety and Justice Committee and Federal Affairs Task Force Committee. Let's begin with a roll call, Nancy.
Vice Chairperson Lee
Good morning, President.
and Chairperson Ellenberg.
I'm here as well.
Thank you. We have a quorum.
Thank you. We have a variety of new faces with us on the dais this morning. Welcome to all of you. I will go to public comment. This is the portion of the agenda set aside for members of the public wishing to address this committee on matters that are not on today's agenda but are within the purview of this committee. We'll hear first from speakers in chambers and then on Zoom. We'll close the speaking queue before the first person begins so that we know what our total number is. And I will give Nancy a second to figure out what that number is.
We have 2 speakers in chambers and 1 on Zoom.
All right, I'm going to make a last call for public comment. We have 3 speakers right now. No one else is joining. Let's close the queue at 3 with 3 minutes per speaker, please.
Okay, our first speaker is Paul Soto. Please approach the podium, followed by Melissa Valdez.
Good morning, Board of Supervisors. My name is Paul Soto from the Horseshoe. I'm concerned that the past 3 serious cases, Michael Tyree, Juan Nunez, and Andrew Hogan, all 3 of those cases were satisfied with payouts and no fault agreements with the families. And what that has done is that has placed the public, me, at a disadvantage because you're privy to information that I, as the public, I don't have. And so when we put items on the agendas for discussion, how are we supposed to challenge anything when we don't know what we don't know? You know what we don't know. That's a problem. And significant amounts of my money, public money, was paid out in order to have that in place because that was public money that was paid out. That was paid out of the general fund. And that money is public money. And so you used our money in order to protect yourselves, the government, whereas you derive your power from the consent of the governed. Can you see how there's a contradiction there? You know, there's a fundamental contradiction there that needs to be articulated very clearly so that we can understand each other and we can come at each other and understand each other and balance out that imbalance of power, because information is power, knowledge is power, and the public is at a disadvantage because we're coming to these meetings and we don't really know what we don't know. The other thing is, no, I'll leave it there. Thank you.
Thank you. Next speaker, please.
Good morning, everybody. My name is Melissa Valdez. I am an organizer with Silicon Valley Debug. And on April 26th, my cousin, Angelo Spencer, passed away inside Maine Jail. He was a loving son, father, cousin, and a funny person as well, and a friend. I would like to take a moment to ask the board members and others to join us for a moment of silence. But before that, I would also like to add that me and the family have been asking the sheriff for an in-person meeting, and that has not happened yet, nor have we had a response. So if we can please just take a moment for him. Thank you. Thank you, everybody.
Thank you. I'm very sorry for your loss. Next speaker, please.
We will now move on to our Zoom speakers. Our next speaker is Parent. Please accept the unmute. You have 3 minutes.
Yes, hello, good morning. I'd like to bring to your guys' attention a case that was in 2016. It was involving Valerie Ray Berry. It was well publicized in the news media at the time. And what happened in that case was this woman, she caught her husband putting his head between the child's legs in a bathtub. And the husband, he stated that he was just blowing bubbles. But the mother said it was a sexual act. And in any case, she separated from the husband, was trying to get a divorce. And the lawyers wanted the husband to have unsupervised visitation and custody. And it didn't work out for her. So against the court order, she fled to another state. And the DA's office put out a warrant for her arrest. And they ended up extraditing Ms. Berry from the state that she was living in. And they put her in jail for an entire year. And then after she was released, she was on 3 years probation. I mean, is this really what the DA's office does? Because they're doing the same thing to me. They're punishing me because I want to protect my children. I didn't even violate a law. I didn't violate a court order. And by allowing the sexual abuse of my children to continue, you allow a predator to continue to volunteer at several schools in Cupertino and San Jose. What is wrong with this county? I mean, look at this other case. I mean, you could have been using that time to prosecute rapists and killers and bank robbers, but you didn't even take into consideration that this poor mother's child was molested. I mean, my son, he's already confirmed that my ex-wife was letting somebody rape him. What more do you need to act? I mean, this county is starting to legitimize and decriminalize pedophilia. It's wrong. Please, is there somebody here that can help my children get a screening? That's the least that they deserve. Give them a screening. Please. Supervisor Lee, he's got all my contact information. Please help me. Thank you for your time.
That was the final speaker.
Thank you very much. Next item on our agenda is approval of the consent calendar and any changes to the committee's agenda. Supervisor Lee, do you have any changes to the consent calendar?
Yes, if agreeable, I would like to add items number 8 and numbers 5 onto the consent calendar.
I would like to keep 8. Let me
Okay.
see what 5 is.
5, just
No, if you don't mind, I do have questions and
okay, all
comments
right,
for
sure.
both of those
Okay, that's fine.
items.
We're just going to hear it.
Are you comfortable making a motion to approve as is?
Yeah, otherwise I'll go and get the approve the consent calendar.
Thank you. I'll second that. And before I go to public comment, I'll note that I don't have changes or additions, but I just want to draw attention that item 11, the annual use of force report from the sheriff, is simply an updated report. It was attached as a supplemental item to the agenda to reflect the board's direction when it was heard 2 weeks ago at the April 22nd Board of Supervisors meeting. And I look forward to receiving responses to those requests in a future report. Thank you. Do we have public commenters on the consent calendar?
We have one request to speak in chambers. Paul Soto.
Do we have any speakers on Zoom?
No speakers on Zoom, just the one in
Okay,
chambers.
we'll close the queue with one speaker in 2 minutes, please. Just have to reset the clock. Hang on 1 second, please. Go right ahead.
Also from the Horseshoe, one of the things that, thank you for making that announcement, because I was looking at the agenda and the use of force report wasn't in there, so thank you for clarifying that. Use of force, I was looking at the, I was looking at the DA's report for another item, but it talked about, there was like 6 murder trials, 6 convictions, and then 6 attempted murder, 6 convictions. And it just troubles me that, and this has to do with use of force, because Michael Tyree, those men were guilty of second-degree murder. They literally took him in there and stomped him to death, and that takes a lot to do. To stomp a man to death, that takes a lot. And there was already premeditation, because you guys already know that that dude's shoulder got busted earlier in the night. And so these dudes were literally hunting, and they were looking for the most vulnerable person, and they found him. You know, and and those dudes beat their case, they come back, and they just get released. Credit time served. That's it. Like, what if that was your son? What if that was your daughter? You know, you would want justice. Michael Tyree deserved nothing less. Under equal protection under the law, he deserved nothing less but that. The same kind of penalty that you would want for your child. And so this is what I'm talking about, is that we really have to get to a point where we humanize the systems that necessarily are designed to dehumanize. That's the direction that we need to get to. And I think that we have the administration in place to do that. And I'd like to work with you on that, to humanize systems that are designed to dehumanize. Thank you.
Thank you. Let's vote to approve the consent calendar.
Vice
So moved.
Chairperson Leaf
Aye.
and Chairperson Ellenberg?
Yes.
Thank you. Motion carries.
Thank you. The first item on our regular agenda today is item 4, to receive a report from Custody Health Services relating to operational updates. And welcome to all of you making your way down to the tables.
Good morning, Vice Person Ellenberg and Vice Chair Lee. Rosia Luna, Director of Custody Health. With me are part of our leadership team. To my right, Dr. Yi-Chao Wong, who is our Medical Director. And to my other right is Michelle Delacaya, who oversees our Justice Involved CalAIM initiative. And then to my left is Dr. Holly Child, who's the Director of Restorative Services with our Sheriff's Department. And then Dr. John Daly, who is our TBH Psychiatry Medical Director. Today we have a report that provides you with a few key operational updates in custody health, which includes the initiation of our EASE program and also our updates in regard to our medical JI initiative, and of course our ADA enhancements. While we don't have a formal presentation for you, this team is happy to answer any questions you may have.
Terrific. Thank you very much, Dr. Luna, and thank you to all of you for the work and the report on the custody health programs, including the CalAIM Justice Involved initiatives. I do have a number of questions, but I'll look to see first if members of the public would like to weigh in on this item. Nancy, do we have speakers on item 4?
We have one request to speak in chambers and none on Zoom.
All right, let's hear from our speaker, please.
Okay, our first speaker
You
is
stand at the podium, please. The microphone is built into that. Thank you.
Ray Kitty.
Yes, hello. I was actually going to try not to speak today. These are always hard, these 2 minutes. I just wanted to say, I was looking at the report, the CalAIM. There is a disconnect between policymakers and what actually happens in the jail. For instance, the thing right there says CalAIM connects people to their Medi-Cal services starting 90 days before their release date. But if you look at who's in jail, who has a release date? 10% of the people in the jail have a release date. So if there's a 90-day delay, that's not going to really do it. If there's a 30-day delay, there's not going to do it. I mean, really, you need to be at the moment they get released. Why were their Medi-Cal benefits removed? Why was their ID cut up? Why are their options not more available starting out? If you're relying on X number of days before release date, that's going to be a problem. That's it. Thank you.
Final speaker.
Thank you so much. Let me start with some questions on the CalAIM JI initiative. The data as of April 8th shows that since the county began implementing CalAIM JI as one of 3 pilot counties last October, we've activated Medi-Cal pre-release services to more than 4,200 adults and nearly 200 youth. That really is a significant milestone. I'm pleased to see this initial early progress being made in the rollout. I understand that we're still in early stages of implementation, so as a follow-up, I think a year would be appropriate, but I'm happy to have your input, Michelle. In that next update, which I think should become annual, I would be interested in seeing in greater detail information about the number of patients receiving each of the CalAIM JI services, as well as more information on performance and outcome measures. Michelle, I want to particularly thank you for connecting with my team and helping us understand the performance and outcome data that you're thinking about tracking and reporting on, such as the percentage of individuals leaving with a discharge or reentry plan, rates of repeat admissions, and engagement in care coordination. Ultimately, what I'm fundamentally interested in is understanding whether these efforts are making a meaningful impact for people both in custody and as they transition back into the community. So thank you for that. And the speaker's comment was actually something that I've been wrestling with also and have asked, I think, a number of times, and I think I might finally understand it. But let's go through it together. I understand that Custody Health and OSIT don't know the release date for the vast majority of patients. So how are you determining when and how to activate Medi-Cal services while they are in custody? And I think that's going to require an explanation of the difference between Medi-Cal AIM JI specifically and Medi-Cal Medicaid coverage generally. And then within that or following that, I'm interested to know whether there's some prioritization for whom you engage in deeper services and care coordination. And to be clear, the suspension of Medicaid, Medi-Cal while people are in custody is a federal and very unfortunate rule. I will offer my opinion here that it makes no sense to suspend reimbursement for care while someone is in custody. We still provide that care, but it means that it all comes from the county general fund and none of it is reimbursable. Michelle, take it away, and thank you.
Thank you so much for the question, Supervisor Ellenberg. I will do my best to try and explain this very complicated issue.
Thank you.
And I'm going to start first by talking about 3 processes around Medi-Cal during the justice involvement here in Santa Clara County. The first is Medi-Cal application. So if somebody comes in and they are not eligible for Medi-Cal or they have not applied for Medi-Cal.
When you say comes into custody?
Comes into custody and they don't have Medi-Cal active. There are processes in place currently, and we are working closely with the partners that are doing these processes to improve them, to support application for Medi-Cal while incarcerated. So currently, we partner with Holly's team, Dr. Child's team, and the rehab officers, and we're streamlining processes across social service agency and our team and Holly's team to ensure that everybody who is interested in applying for Medi-Cal gets that opportunity to be supported in their application process while incarcerated, and to turn on those benefits, make sure they're eligible for those benefits as early as possible during their incarceration. So that's one unique
But those
process.
benefits won't actually kick in until they leave
Right,
custody.
right.
So we're teeing them up so that there's no delay when they're released.
Great, yes, and.
I'm just repeating to
Yes.
make sure I understand. Thank you.
And the social service agency has a process to expedite those applications for those folks that are in our carceral settings. So that's one unique process. The second process you mentioned is that suspension and unsuspension of benefits. And this affects those folks that have Medi-Cal active while in community, enter our carceral setting, and on day, I say 28, but it might be, we notify on 28 and they suspend on 29. And that is the suspension of benefits. So when somebody is in community, there is a managed Medi-Cal benefit where they have a capitated rate going to an insurer to provide those services while in community. Because they're not in community during that time and not receiving services, that benefit is suspended while they're incarcerated. That suspension occurs on day 28, and there's a requirement by the state that that communication happens. Unfortunately, like the public speaker mentioned and that you commented on, that unsuspension of benefits upon release, there's not a stringent requirement, and so we're developing more comprehensive processes to ensure that that unsuspension of benefit is done for not only those with a known release date, but also for those with an unknown release date, which, as noted before, is about 90% of the population that is incarcerated.
So we don't have a
Street,
rigid policy where we will not begin the process of unsuspension if we don't have a 90-day pre-release date. We begin it anyway when they come in?
yes. So we're Dr. Child's team and I are working on solidifying a more robust process to ensure that social service agency knows when somebody is released and can do that unsuspension without being prompted by the individual in community going to social service agency or making a phone call. And that is unrelated to the third process,
Right.
which is the JI.
The CalAIM JI, okay.
So those two are separate processes. The third process is what I reflect in the CalAIM JI initiative, which is the turning on of the benefit that an individual who's incarcerated may be eligible for in the 90-day pre-release process. That is a separate system that the state has stood up for this initiative, where we manually go in and enter each individual to turn on that benefit if they meet the criteria and they have Medi-Cal.
And they have a release date?
No, we are
Okay,
actually
so-
entering it because 90% of the population doesn't have a
Right.
release date, but also 90% of the people that are leaving leave within 90 days of arrival to our institutions or our carceral settings. So we're making some assumptions that the majority of people will leave. So we're trying to initiate that very early in the process when either they come in with Medi-Cal active or they activate Medi-Cal during their incarceration. And we are working as one of our other key initiatives and priorities of this initiative is anticipating release. So, so the JI process, we're turning on that aid code when we, I think we've gotten to day 7 of incarceration, and then we're turning it off when they leave. Unfortunately, to me and my team, and also actually to the state who was here with us on a site visit last week, learned that those things don't communicate with each other, and so that doesn't trigger then the unsuspension of benefits. So these are things that I think we'll be able to work on over time to kind of streamline those processes, and the state has been working very closely with us as one of the key leading counties in this to make that progress. So we're hopeful that we'll see progress on that and have some automation of that, but it's a work in progress. So and then I can answer the next one on prioritization if you want me to go to that.
Let me
or if
wait
you
for a
wanna-
second.
Perfect.
That was too much in one question, and I'm impressed that you remembered. Thank you. But let me stay with this for a minute. CalAIM-JI provides reimbursement for services while someone is in custody. So that's a new thing that we are getting some reimbursement for some of the services that we provide to some people in custody.
Yes.
Awesome. When they leave, since CalAIM-JI follows them in the transition and their regular Medi-Cal turns back on, do these two overlap? Do they each cover different services? Or does one have to end before the second one begins?
Yes, and.
Cool.
So the JI aid code allows the claim submission for certain activities during the period of incarceration. That includes things like lab tests, x-rays, physician visits, and medications. If that JI aid code is turned on and the claim comes through and the date of service matches the date the JI aid code is turned on, that claim will be adjudicated and we will be paid for that claim. So, and then on the day of release, or the day after, or the Monday after, we turn off that aid code with the date of release. And then if a claim comes in for the same, a lab test, a physician visit, those kind of things, and the JI aid code is turned off and the date of service reflects that the JI aid code is turned off, then that would be paid through the standard Medi-Cal benefit in community.
Thank you.
We are working with the state because we are finding some errors in that, and so we, again, have the state's ear to try and
Good.
solve some of those issues, including some of the things that cross over into the behavioral health realm.
Great, and I imagine our IGR team is connected with that as well. I realize that this may sound tedious and not sufficiently public safety or justice-y, but it is such a critical piece of building toward equity in the way we treat people and the way we care for people. And yes, it also does save some general funds, which we can then use for other things. But I think most importantly, it recognizes that whether someone is in or out of custody, they are deserving of quality medical care. And pilots like CalAIM-JI and the new rule of starting the process to reinstate Medi-Cal earlier, I think are important moves in that direction. And just as one supervisor, the better I understand it, the more easily I can talk about it and explain why this really does matter at a big policy level and that it's not just an accounting issue. I'll ask you to respond about prioritization and then look to other folks who are equally interested in the wonkiness here.
Great. So the next question is, how do we prioritize who gets that extra layer of support in terms of the reentry planning, the connection to enhanced care management, which is a benefit available in the community for anybody who qualifies for the JI initiative while incarcerated. Because this is a new program and we're working in partnership with Custody Health, the programs team under Dr. Holly Child, probation, and so many other people that are involved in the care, the reentry center, community-based organizations, the faith-based organizations. We're really trying to figure out how to prioritize those that need this level of support the most, and that we can understand when to start and stop that service. So we have a team that we're calling Care Coordination and Discharge Planning under my direction. And we are looking for those with a known release date. Any referrals we're getting from the Public Defender's Office and some from the courts and some that are self-referring that believe they're being discharged soon. And we're adding that additional layer of support. And then we're looking to expand that by having additional case conferencing with multiple teams, as well as partnering across Custody Health and the programs unit, all these different players. We're really trying to hone in and make it make sense. as well as not step on each other's toes in that process. So we're learning together and in partnership with a lot of folks around this table, around the community, around the dais. So we're really trying to do that in a thoughtful and meaningful way. And it's hard. So we're learning and we're moving through it. But as you see in the data, we are making progress on these things, and some have gone from 0 to something. So we're really hopeful that we'll keep making progress. And I'm thankful for the year to really document some of those things and establish some of those process and outcome measures.
Fantastic.
Well.
Thank you. Thank you so much, and thank you for explaining really complex systems in a very clear way. I'll go to my colleague and then to Acting Public Defender Damon Silver. Go ahead.
Thank you, Chair. Yeah, so first of all, thanks so much for the good report. And the question that was asked, I think, were answered regarding this issue of how, 90% of those in custody do not have to confirm release dates and how that trigger the regular Medi-Cal coverage. So just based on the answer of my learning today is that regular Medi-Cal turns on 90 days prior to release. But then you said something about how Medi-Cal is now being activated upon incarceration because the CalAIM JI provide folks being incarcerated. Is that correct?
Let me try and restate the
Yeah,
question
it's
because so sometimes it feels like semantics, but it is important, kind of the language around it. So
Sure.
Medi-Cal, if I were a Medi-Cal recipient today in community, and I was incarcerated,
Right.
my community benefits would be suspended, although I'll remain Medi-Cal eligible during my incarceration. So Medi-Cal itself isn't suspended. The benefit is while you're incarcerated. During that incarceration period, if I qualified for the JI initiative with a disorder or one of these other things that qualify, most people would qualify. A benefit called the JI benefit would be turned on upon entry if we anticipate me to release in 90 days, or 90 days prior to release if it's a known release date a year or two out. So those are those criteria. The JI benefit would turn on when we activate that in the portal, the state portal, would turn off when we deactivate that in the portal based on release date. The community benefit that I would be eligible for upon release would be turned on upon release, if with a known release date, or upon my reactivation of that by calling social service agency, going to the reentry center and meeting with the eligibility workers there, or when we streamline the process of notifying social service agencies of those people with benefits suspended during their incarceration so that those can be turned back on without initial work. Is that clear? I know it's super
This is a
confusing.
lot, yes.
It's a lot.
And so I'm trying to, and so on the release date, so if they've been getting JI, upon
Yes.
release, they would be deactivated, you're saying,
Yes.
upon release, but then they would activate the
Right.
regular.
Yes, the regular benefit would be resumed or activated.
So
depending
then
on-
there's no gap, right? But that's the
There
whole
should
point.
be no gap. And the biggest gap is if we don't know the release date, they're released on the Wednesday night before Thanksgiving, where there's a 2-day holiday and a weekend where there might be that gap. That social service agency can't turn that on. Other than that, you can just, the benefit would be there. And again, our services in the Santa Clara Valley Healthcare, I know, are receptive, and we work out processes with pharmacies and the like to be able to do that.
So if it's not turned on in time, it doesn't mean get turned away from our system. I mean, our county hospitals, I mean, we receive everybody, right? So basically, the real problem is not so much lack of service, it's just that the county won't get reimbursed for those services. Am I correct?
The county may get reimbursed because you can turn on that benefit backwards, right?
Okay, so we could retroactively
Yeah,
turn them back on
yeah.
too. Okay, all right. So I think it's just important that during this gap period, individuals should know that they should come to county hospitals upon release if they have
Yes.
medical need.
Yes, and come to reentry centers and seek support. And if and when we work with them prior on this, connecting them to enhanced care management and anticipating release, we hope that we'll be able to streamline that even more so that the person at the center of this work and world doesn't have to know the nuances that we're talking about today. That's my hope, and I think the hope of many of my colleagues up here.
Okay, thank you.
Yeah.
And that's my question. Thank you.
Thank you. Damon.
Yeah, thank you. I just wanted to express why I have such a high level of confidence and have been so impressed with Michelle and her team. And I'll just use this one example. I recently had an opportunity to travel with her and a member of her team to a national conference. And I left with 3 observations. One observation is, and I think we've already seen this is very technical and quite complex. The second observation is it's clear that Michelle and her team are leveraging a statewide network to basically build and share knowledge across the state and implement it in our county. The third observation I would share is it was clear that Michelle and her team are seen as experts in this space statewide. And I think that doesn't probably come as a surprise to anyone just watching her navigate the questions that she's fielding. So I just wanted to acknowledge that I have a very high level of confidence in her and the way her team is approaching this, and just want to thank her for the service that she's providing our clients.
Thank you.
Thank you. Greta, Chief Operating Officer.
Well, Damon, thank you for that praise for Michelle and for the entire team that's working on these efforts, and really appreciate that acknowledgement. In part, just wanted to note that I think because for this team and countywide, there's so many more things that we want to be doing, and we often focus and are getting more feedback around the areas where we're not yet hitting really the goals that we're setting for ourselves. But I appreciate your comments and just really want to make sure that we can all try and provide context as we're grappling with really difficult challenges around how far ahead of most communities we are. I think we've been, in the midst of some challenging conversations about just how difficult it's been for us to meet our own goals for example, offering housing support for folks exiting custody who are really struggling with addiction or mental health challenges. And we are doing so much more than just about any county, if not any county in the state of California, investing more in that effort. And yet, I think we collectively hope that some of these opportunities to draw down additional resources will give us the fiscal capacity to really provide the services that are needed for every single person, because we know we aren't hitting that mark, but really important for our broader community and every stakeholder engaged at Public Safety and Justice and our partners in the cities throughout the community to really understand that even though there is immense need in the community that's not currently being met, that we are light years ahead of where most communities are on these issues, and that doesn't give us a pass in any way on the work that needs to continue to be done. But I think it's really critical context for folks to understand that the investments led by this board in a lot of these areas are immense compared to what most communities are making, and will continue to really try and shift the needle towards prevention and rehabilitation, while also making sure we have the resources needed to do all the other core criminal justice work that needs to happen.
Great, thank you very much. Javier.
I also want to emphasize the point that Michelle made in terms of needing to identify which clients will need a reentry plan in custody out in the community. So currently, as of March 31st, between the 4 faith-based centers and our 3 service navigators, there's 627 active cases with reentry plans. So that's 627 individuals with active reentry plans. And we're working with her team to kind of identify what should those reentry plans look like and what are some of the priority needs. So in terms of moving forward with budget discussions next week, there might be some needing to revisit those reentry plans and the number of service navigators working in custody in the community. So that's something that we're already in discussion with Michelle and her team.
Thank you. Supervisor Lee, something else?
I'm good.
Any other comments? Under Sheriff Rodriguez?
Sorry, this one's a little bit better. I just want to thank you for the report. I think it was really well written, and it really gave us a really good idea of how the program works. I'm really super excited to see that you do have your 75 people that are currently in the program and how you're going to be following them in the future. I think that's going to be critical for us to know. It's always good to really see the progress that they're making. I think that's going to be one of the things that I would really like to know in the future is see how the program is working, the challenges that you're facing, and then the success of the individuals, because I think it also inspires others to kind of continue that path. Thank you.
Yeah, thank you. I agree, and we'll look forward to seeing that a year from now. Thank you. Would you like to move receipt of the report?
Yes, motion to move.
Thank you, with the added direction of a
With all
update
the,
in a year.
Exactly. Correct.
Great, thank you, and I'll second that. Let's vote, please.
Vice Chairperson Lee?
Aye.
And Chairperson Ellenberg?
Yes.
Thank you. Motion carries.
Thank you very much. Item 5 is to receive from the Office of Intergovernmental Relations a report related to legislative updates.
Good morning, Chair Ellenberg and Vice Chair Lee. This is David Campos. I'm here in Sacramento. My apologies for not being there in person. We have a number of items that are happening here in the state capitol, which is why I'm here. And with you today in San Jose are Monica Tong, who is the program manager who oversees operations for intergovernmental relations, as well as Elaine Trin. Let me begin by simply noting that this is a very critical time for the legislature. They have recently, in the last few days, wrapped up the policy committees and are now turning their attention to preparing for the May revise, which will be coming out next week. And so we're eagerly waiting to see what is done. Because as you can imagine, depending on what is proposed in the governor's revised budget, it may make things worse in terms of the cuts that are being proposed at the federal level. This is a semi-annual report that we provide, and the next report will encompass the final 2025 update. So with that, let me turn it over to Elaine, who will continue with the presentation.
Good morning. The slide before you represents some upcoming key dates. And so this year, over 2,300 bills were introduced, and the bill introduction deadline was in February. Bills are being heard by policy committees in March and April. And so this is a season where we engage the most on bills, working with legislators and their staff. Last week was a deadline for policy committees to hear bills with a fiscal impact to the state. And so a few key important dates that are coming up is that today is the end of the first House Policy Committee deadline. Tomorrow is the statutory deadline for policy committees to hear bills with no fiscal impacts to the state. And as David mentioned, we are anticipating the release of the May revise, which is due on May 14th. May 23rd is the suspense day, or the last day for appropriations to report bills to the floor or to hold them. And then June 6th is the deadline for the House of Origin. So it's the last day for each house to pass bills that are introduced in their house. And now I'll turn it over to Monica.
Great, thank you. So this year the county is sponsoring 3 bills. All 3 bills are authored by members from our delegation. SB 261 is authored by Senator Aisha Wahab and co-sponsored by the Civil Prosecutors Coalition, and aims to encourage businesses to satisfy their outstanding wage theft judgments by increasing transparency and tripling penalties. SB 261 has passed both policy committees on a 4-1 vote and an 11-0 vote, and it is currently on the Senate Committee Appropriations suspense file. So we'll learn its fate on May 23rd, as Elaine had shared. AB 243 is by Assemblymember Patrick Aarons and increases access to affordable higher education for systems-involved youth, including justice-involved youth and those served by the child welfare system. Oftentimes, these youth pursue their educational goals and face obstacles that can hinder their pursuit of this higher education, including things like two-factor authentication. The bill will require financial aid administrators at most public higher education institutions to accept an attestation from local educational agencies, county probation officers, or welfare departments. AB 243 also passed its two policy committees on an 8-0 vote and on consent on a 12-0 vote. State costs for AB 243 are minor and absorbable, so that's good news, and the Appropriations Committee passed that on consent. Last week, the bill passed the Assembly floor on consent and is currently awaiting referral by Senate rules. AB 1025 by Assemblymember Gail Pellerin authorizes a new tool where families can authorize another adult to care for their child or children in advance of potential separation from their minor child or children. This is called a standby caretaker and would be activated in situations including adverse immigration action, medical necessity, military deployment, etc. Existing law provides several options for families at risk for separation, but each presents some limitations. This standby caretaker option is modeled on policies from New Jersey and Maryland that prioritize the rights of custodial parents and support simplification for reunification. This caretaker model also does not require caregivers to file anything with the court prior to the activating event, which was something that our community needs. Question?
No, I'm just noting that respectfully that we can read the slides as well, and I would
sure.
love to hear highlights, new things that are happening that need to be on our radar right now. I love that we always get a comprehensive vision of what's gone on before. Thank you.
Happy to turn it over to David for the PSJ bills.
Thank you very much, Elaine and Monica. Madam Chair, as you know, the way that we approach our positions relative to legislation is that we have the policies that outline general positions that we have, and then we ask for specific feedback from the departments. And I want to thank all the departments who have engaged with us and are very responsive. I also want to thank Casey Halcon, Deputy County Executive, who has been very helpful in the area of public safety and justice. And I want to highlight a couple of bills in this sphere that we have been working on. We are supporting AB 67, which is a bill by Assemblymember Bauer Khan. The bill allows the Attorney General to file lawsuits to enforce the Reproductive Privacy Act. The act dates back to 2002 to protect individuals' privacy related to the reproductive decisions and prohibits government interference in those decisions. And recently, local governments throughout the state have interfered, unfortunately, with those decisions, and so this provides more authority to the Attorney General. We're also posting AB 470 by Assemblymember Tina McKinner. This is a follow-up from last year's AB 2797, and it's a pathway for AT&T to be relieved of their obligations as the carrier of last resort. This year, they're attempting to narrow their relief, but it creates a public safety risk, as we know, because many folks would be left without reliable options to receive emergency notifications. We're also supporting SB 59 by Senator Scott Wiener, which is known as the Transgender Privacy Act, with the federal administration targeting the transgender community. This bill would automatically seal all court records related to gender transitions. And then lastly, the county is supporting SB 258 by Senator Wahab, which closes a loophole in existing law that permits rape of a spouse who is incapable of giving legal consent due to a disability. This leaves married individuals with disabilities with fewer protections against sexual assault. SB 258 is an important step towards supporting all survivors of sexual assault regardless of marital status. So that's just sort of some highlight of some of the things that we're doing in this space. And at this point, happy to take any questions from the committee. Thank you very much for the opportunity.
Thank you all very much. The detail in the reports, I think, is really critical, and I certainly hope everyone reads them. I think this team, really in the last couple of years, David, Elaine, Monica, and your counterparts in Sacramento have just stepped up our engagement in such an impressive and, even more importantly, such an impactful way. So thank you. Do we have public speakers on this item?
We have 2 requests on Zoom and none in chambers.
None in chambers? All right, let's hear our speakers on Zoom. Thank you.
Okay, our first speaker is parent. You have 2 minutes. Please accept the unmute. You may begin.
Yes, I'm so glad to hear that we're working on legislation to support survivors of sexual assault, no matter what their marital status is. But I think more than the legislation itself, I mean, we do have to, we do need to uphold the laws that we already have on the books. And my 2-year-old, right, he has no ability to consent to sexual contact with an adult. And I should be able to go to the DA's office, and I should be able to tell DA Rosen personally that all the details of the sexual assault of all my kids, without the fear of being shortly thereafter being prosecuted. I mean, it's just terrible what's going on in this county, that lawyers, private attorneys can do whatever they want. They can sex traffic children, they can assault parents, and then after all that, they can influence the district attorney into prosecuting parents who just don't like that their kids are being sexually molested. I mean, these parents don't even have to commit a crime. Maybe Valerie Ray Barrett, she violated a court order by moving to another state with her child, but I didn't. I didn't violate any court orders. I didn't violate any laws. All I did was tell DA Rosen what was going on with my kids. I mean, he's flipping the script, right? He's saying these parents that report it, they're bad, they're crazy, they're whatever, and the other person who's molesting the kids, they didn't do anything wrong. They didn't do nothing. Please, let's change it.
Looks like we have a public speaker who did miss the cutoff time, but we also had a speaker who dropped from Zoom, so I would welcome this speaker to come in, but I do want to remind everyone that the cards need to be in before the first speaker begins speaking. But let's hear our speaker today.
Okay, our next speaker is Raj Jayadev.
Hi again. I wasn't sure if this is an appropriate place to bring it up, but since folks are talking about local bills, I wanted to see if the county would be interested in supporting a bill that was generated by families here in San Jose who had lost loved ones to police violence. It's sponsored by Representative Clara, called AB 572. It's a bill to stop the police interrogation of families after the police have killed their loved one. It turned out, due to the conversations with local families, that there was actually a private firm that was training police departments of how to extract information from families in officer-involved shootings in order to sanitize the actions of the officers and implicate the person who was killed in the cause of their death. And so oftentimes the stories we heard from here in San Jose, like Diana Schulman, like Philip Watkins, when the police killed their loved ones, SJPD was trained on withholding the information of the status of their loved one's health condition, whether they're dead or alive. And so they would say, why don't you come down to the station? We'll give you some answers that you're looking for. And then that discussion would quickly turn into a trained interrogation where their cell phone would be removed, they'd be separated from other family members, and they'd be asking interrogation questions about the person who had died. And so when we found out that this was a statewide practice, families in San Jose reached out to other families across California and then generated a bill that acts as a level of protection for families to say police have to notify the status of the person's health condition before asking questions. Families are not obligated to answering any of those questions, just as a way to offer some measure of protection in a really difficult, dizzying time right after the fatality of a loved one. And we'd hope that the county would support the initiative.
Thank you so much for that information. That's AB 572, and I see some nods. I want to flag another Clara bill. Please, this is AB 1258, which seeks to extend the juvenile probation deferred entry of judgment, the DEJ, pilot to January 1st, 2029. And if the bill is not signed, doesn't go through and get signed by the governor, these programs would sunset on January 1st, 2026. This DEJ program is providing opportunities for charges against young offenders to be dismissed and their cases sealed if they successfully complete probation. Participants receive behavioral health counseling, substance use treatment, are offered supports with housing, education, and employment. And I wonder, do we have anyone here from probation? We don't. Oh, hello. You're Mark Etsy?
Correct.
Mark, it is nice to meet you. I wonder if you could just say a word about how the DEJ programs have performed locally and whether we're seeing a significant reduction in recidivism rates and whether this is a program you think is worthwhile to continue.
Currently, I think it's worthwhile, but we're still gathering more data just to see, what kind of information we can abstract from it. I know we have our managers over at the Adult Probation Department and the supervisors that are closely watching that program and seeing that success rate. I think that rate right now from the stats that they have are currently at probably about 82%, I believe, success rate for right now. But I would have to dig more into that information to get a more comprehensive kind of like a report out on it.
Thank you very much. I would ask the team here to look into what it would look like to support that bill. And I have heard from Chief Burchard, I'm sorry he's not able to be with us today as well, about the strong success rate of this program. That's all I have on this item. Supervisor Lee?
No, nothing further to add, but I just want to thank the speaker for bringing up AB 572. Would love to learn more about this issue and probably talk to our public defender, Damon Silver, on this moving forward as well. Thank you.
Thank you. Comments or questions from anyone else? All right. I'll move receipt of this report.
And certainly I'll second that.
All right. Let's vote, please.
Vice Chairperson Lee?
Aye.
And Chairperson Ellenberg?
Yes.
Thank you. Motion carries.
Thank you very much. Item 6 is next. We've received an extensive report from the district attorney. My team did discuss a little bit earlier today our request to hold the presentation, the verbal presentation, to 5 slides. We do have the deck, which I have had the opportunity to look at. It's part of the public record. Pardon me. And I'm certain my colleague has as well. So let's hear an abbreviated version of the presentation and then go to questions.
Thank you. First of all, I want to just say thank you to Mr. Silver, who did reach out to me with some questions, but I want to clear up any ambiguity as to slide 7, which I am in no way trying to argue that we are charging white defendants with the gang enhancement as often as we are people of color in this county. That is not what that slide was meant to infer. Obviously, the tradition in this county has been that people of color have been disproportionately involved in and therefore charged with gang crime. Traditionally in this county, we have not seen an abundance of white gangs. We also have had the prevalence of other gangs that has changed over the years. When I became a gang prosecutor in 2005, we did have a fairly substantial number of Asian gangs that were active in the county. That has decreased significantly in the last 20 years. But what I meant for this slide to impart is that when the DA's office does receive a gang crime from a law enforcement agency that depicts that the crime was committed by a white individual, overall, the statistics show that we are charging more often the gang enhancement on those individuals than when we are receiving a much larger number of referrals for other people. So I don't want there to be any ambiguity in that. I agree that disproportionately people of color are represented by gang enhancement in this county. When I was last here in January of 2024, Supervisor Chavez had asked me to focus more on juvenile gang crime in this report. There's different hurdles that we face in reporting out on that, but I did try my best to come up with some numbers that I can share. I'm just not going to go through my entire PowerPoint, but instead focus on a few specific slides. So one of the things that Supervisor Chavez asked before she left was for me to look at the age of the individuals that we are charging with adult gang enhancements. So 23 was the average age of those currently charged with gang crimes within the period that we were looking at, which was January 2024 up through, I believe, March of 2025. 18 individuals were either 18 or 19 years old, 27 were in their 20s, 8 were in their 30s. We did have a number of individuals that we believe committed gang crimes, but that were juveniles, but we treat gang crimes in juvenile a little bit differently. First of all, it's difficult to get some of those numbers because in probation does not, go to that slide, probation does not label a crime and or a minor as gang involved, and they haven't for a while. Because of that, it's very different to kind of cull that information from probation. The district attorney's office has really transitioned to rarely charge a gang enhancement on juvenile crimes. Juvenile is treated very differently. The purpose of juvenile is very different. It's really focused on rehabilitation. The sentencing is drastically different than that we see in adult court. Based on that, the DA's office has rarely filed a gang enhancement on juvenile crimes. Therefore, it's very difficult to kind of look into our system and pull out what we believe to be gang-related crimes in juvenile. So one of the things we were able to do for the time period that we're looking at during this reporting period is we looked at all of the adult defendants that we charged with a gang enhancement, and we looked to see how many of those individuals did have a previous juvenile history, and only 13% did. We worked really closely with probation, and I want to thank them for giving us some numbers, but basically the numbers that we were able to look at were that first of all, they didn't have any numbers for 2024 that we could look at yet. They just didn't have those numbers yet. So we looked at 2023, and I apologize for that. But from the time period of 2023, there were 251 juveniles that were referred to juvenile probation department for the types of crimes that we traditionally charge with a gang enhancement in adult. So one of the things that I was questioned on in an email that was sent to me was, isn't it true that gangs also are committing nonviolent property crimes? That is absolutely true. They're also, yes, they are involved in narcotics trafficking. The DA's office has made a conscious decision over the last several years to charge the gang enhancement even more sparingly than we have traditionally. And we have made a conscious decision to really focus on violent crime. It's a matter of resources by both law enforcement at the DA's office and also the court's resources. With legislation changes, obviously, we are now having to do 2 trials on many gang cases, both the trial on the predicate, on the actual offense, and then separately try the gang enhancement. Because of that, we really have had to make a choice to really focus the gang enhancement on those crimes that are the most serious. So when looking at the juvenile crimes that correlate to those adult crimes, and then looking at one of their assessments, their risk assessment tools, where they have, one of the risk assessments is negative peer group. We were able to say that we believe 25% of those juveniles were believed to be either affiliated with gangs or negative peers. I think this is a very low number, to be honest. I think there is a large number that we're not catching in that. But that was the best that we can do, and I'll continue to work with probation to see if there's a better way to flag this. Also, at the DA's office, we are considering a way that we can flag what we believe to be a gang-involved youth without charging them with the gang enhancement. One of the questions that I believe the board has been concerned about is what appears to be an uptick in gang violence this year in 2005. So I will say that there has been a noticeable increase in gang crime this year so far. The number of cases charged by the gang team doubled between January and March. Sometimes, in my experience, having been involved in gang prosecution for the last 20 years, I do think that there are years where gang crime does increase, and I do think part of that is because some of the gang crime that we do see is retaliatory in nature. So because of that, if you may happen to see a year or a few years span where things are particularly violent, and that happens occasionally. When I was a brand new prosecutor, it was a very, very violent year for gangs between the years of 2005 and 2007. So the nature is that some of this increased crime that we're seeing may be a product of that, may be a product of something else. It's hard to say. As of April, we had 5 homicides in the county. 4 of the 5 have been solved, and all 4 of those were gang-related. We believe the 5th is also gang-related, and we're currently working with San Jose to solve that case. We have charged 19 adults and juveniles with murder or being accessories to murder since January. In addition, we did have an extremely violent homicide at Elmwood that we charged, I believe, in January or February of this year. And then a month later, we had another extremely violent assault in Elmwood that did not result in murder, but was clearly an attempt to murder an inmate, and we also charged that case. So I will say that one of the concerns, obviously, that the DA has is really the secondary trauma that our communities face based on extreme gang violence. So one of the most disturbing things I've seen in my career was the gang beating that resulted in a death. The individuals who were also being housed in that same pod all understand that that was gang motivated and all watched that extremely lengthy and violent attack, and then saw a month later the same exact attempt to murder somebody who was not from this country based on their ethnicity. So the fear that these individuals experience by being in a locked facility and knowing that there are gang members who are controlling that area, I think is really important for us to acknowledge. I think it's the same level of fear that certain communities face when having to send their children to school and also just go about their daily business, when there is random acts of extreme violence that target anybody who looks a certain way without any knowledge if they're gang affiliated or not, is extremely concerning to us. So in looking at the uptick in juvenile crime, I did go through a number of slides with specific incidents that we have charged this year on juvenile gang crime, and it's very disturbing and it's very violent. I'll just for sake of timing, just go over the summary, which is we have charged 16 cases in the first 3 months of 2025 involving gang-involved minors. 38 minors in total were charged, 2 18-year-olds who were housed in juvenile hall at the time of the filing. The minors were between the ages of 13 and 17 when they committed these crimes. Most of the victims in those cases were also minors. There was the use of a knife in 7 cases, and there was a use of gun in 4 cases, but 5 individuals in total were armed. Open to any questions at this time.
Thank you very much. I'm going to look first to public comment. Do we have speakers on this item?
Yes, we have 4 requests in Zoom and 7, 8, and 9. We seem to have stopped at 9 speakers on Zoom.
Let me just make a final call for additional speakers. And what is the total? Sorry, I forgot what you said was in each. Are we at 16?
13.
13 total?
14 now.
14. Okay, we'll close the queue at 14 speakers, which affords 2 minutes for each speaker.
I'm sorry, was that 2 minutes?
Yes.
Okay, thank you. Okay, we'll begin with our speakers in chambers. We have Andrew Bigelow, Raj Jayadev, Paul Soto, and Zach Kirk. If you could please approach the podium.
The podium, please. Thank you.
Hi, everybody. My name is Andrew Bigelow. I'm an organizer with Silicon Valley Debug. I wanted to focus on particularly the juvenile aspect. My understanding of this report is that it was supposed to be almost like objective, statistical, and understanding what's happening. But then there was this allegation, or I don't know what to call it, but saying that adult gang members are using and encouraging juveniles to commit more violent acts because juveniles will receive more lenient punishment. I think it is irresponsible to put that in this report. And I think that it's naive to think that we're not noticing the political atmosphere in this city, in this county. The San Jose police chief and the San Jose mayor have been sensationalizing a tragic incident at Santana Row in an attempt to try to reverse and promote juvenile laws changing to be able to charge people under the age of, I think it's 15 and under. And that's 1391, right? That's the bill that was passed to protect that, because we understand the brain science. We understand that young people are not the amount of their worst mistake of their life. Yet, I do think that there is a movement and a push and a kind of political atmosphere that is trying to reverse those things. And I think that the inclusion of that in this report is synonymous with that. And I want to encourage everybody in here to have the courage to stand on the fact that young people, we need to keep young people in the juvenile system, and we need to not charge them as adults. Lastly, too, if I got a little bit more time, I will say the statistic of white folks being charged at 33%, I appreciate the clarity, but I will say that shouldn't have been in this report, and I think that it's dramatically misleading and unethical. Thank you.
If you've got a card and you're prepared to speak this morning, please come line up.
Paul Soto from the Horseshoe. I was really impressed by the report. You have 47,000 cases that were submitted, and out of 47,000 cases, only 51 were charged. I mean, that shows a tremendous amount of restraint on, because I come from the George Kennedy, Dolores Carr eras, and they were not conservative, with the way that they applied those laws, and so I appreciate that. I'd like to second what Andrew was saying about the mayor Mahan sticking his nose and politicizing these issues. He is. It's very opportunistic, and for a man like that, with that kind of position and that kind of influence and platform, to sensationalize something like that it speaks to him as a man, and he's not much of one, at all. So what I'd like to emphasize is what confused me a little bit is that 33% of the referrals were for white gang members, but 98% were victims. 98% of the victims of gang violence are persons of color. So I was just a little bit confused about that. If you'd be able to, because that would mean that it would be like white on a person of color, and so it's like, are those racial or are those gang related? There's a little confusion there. But thank you for the report, and thank you for showing some restraint.
My name is Zach Kirk. I want to thank the Honorable Board. I also want to thank the representatives of our 3 indigent defense organizations who know everything that I'm already going to say. I was honored to be on the committee of AB 333 in 2021, which changed the gang law. And what I saw wasn't that the due process violations in that gang law could be cured, but that the entire gang law must go. And it's because, I moved to San Jose only a few years ago. I've been in Santa Clara County my entire life, and one thing I know about San Jose is that we have these beautiful historical neighborhoods that are black and brown, where all of the culture emanates from. Cinco de Mayo just happened. All of these cultural delights that we enjoy, but we charge those people from the neighborhood when there are outbreaks or instances of violence, and we charge them on their associations. This doesn't happen in any other place besides our vulnerable black and brown neighborhoods. And we sent some, as part of the debug letter, we sent some of the statistics that we saw in 2022 before the change in the gang law. And I'll read some of them, which is that there were 3 individuals in the CDCR data out of 229 who were considered white. We look closer, those people were actually Hispanic. They're misidentified by CDCR. So there were 0 people in the 25 years of the STEP Act, of the gang law, and there were 0 people who received gang enhancements or a gang charge who were white. Or were European descended. And I had to look all the way at Lake County to find an individual, a white individual who was not associated with one of our neighborhoods who was charged with the gang enhancement. That was in Lake County, a biker gang over 10 years ago. The gang enhancement and gang laws are a tool for profound social control of our black and brown neighborhoods. And instead of giving all this money on the front end that the DA's office spends and the extraordinary amount of resources that I know our defense providers spend, we should be moving this towards resources. I want to thank the board for their time.
And one final call for Raj.
All right, doesn't seem to be here. Let's go to the speakers on Zoom, please.
Okay, our first speaker is Jose Valle. I'm unmuting you. You have 2 minutes. Please accept the unmute.
Hi, this is Jose Valle with Silicon Valley Debug. Unless there's an influx of white gang members attacking POC victims, this report is flawed. According to the report, defendants who are white are as likely to be charged with a gang crime. Yet 98% of victims in cases where a gang crime were charged during this were people of color. Where's the raw data? I understand that Stacey Capps tried correcting herself, but this is a failed and lazy attempt to escape the fact that gang enhancements are predominantly people of color. In this chart, charging involving crimes of violence, it lists crime, total offenders charged, juveniles charged, and adults charged by the gang team. This is misleading chart because this report's supposed to be about gangs, yet lists total juveniles charged while limiting adults with gang charges, creating a bias that juvenile gang crimes are higher or as high as adults. Also, juvenile and adult gang crimes compared to the total crimes is excruciatingly minimal, meaning both juvenile and adult gang offenses are hardly an issue in Santa Clara County. This is further supported as the report states during this time period, 47,000 cases were submitted to the district attorney's office for issuing review. 99 of those cases were referred to the gang team, and only 51 cases made it. That's less than 1% of total cases submitted for issuing, meaning that there's less than 1% of all cases in Santa Clara County that have gang charges. This entire report is lazy and arbitrary. Throughout the entire report, there's words like believe, presumably.
Next speaker is Cecilia. Please accept the unmute. You have 2 minutes.
Good morning. My name is Cecilia, and I am from the east side of San Jose. I echo everything that the previous speakers also have mentioned. One of the things with this slide, although it was explained, it is intentionally misleading, this information. And if that was the case, that there are more white defendants being charged with gang enhancements, and I feel like we should be then protecting our Black and brown communities, because this argument is just so out of place. And one thing that I would like to see is if we could get that data independent, so that we could do an independent assessment of it ourselves. That would be great. As my colleague Zach mentioned, we have been doing this data and this data analysis, and what we found are numbers that are really contradicting to what is being presented. Thank you.
Next speaker is Andrew. Andrew, please accept the unmute. You have 2 minutes.
Hi, my name is Andrew Siegler, and I'm with Surge Santa Clara County, and I'm a voter in District 2. And I just want to say that Surge is fully in support of DBUG's criticism of the DAO report, and also in support of their call for the raw data so that it could be used, so it could be made public for further analysis by the county and public. So yeah, thank you.
Thank you. Our next speaker is Parent. Please accept the unmute. You have 2 minutes.
Yes, I completely disagree that white people who are gang members and commit extreme violence are being prosecuted with gang enhancements. And if I could, I'd like to give you guys an example. Valerie Houghton, Houghton, who is sex trafficking my children, she has a bunch of people that work for her that stalk me, that hack me, and that physically assault me. And the DA knows all about it. I mean, I've sent him pictures of my injuries. She's openly threatening me through social media. I've sent those messages to him. And I mean, like I said before, his only response is to prosecute me in order to absolve her of her crimes. And you can Google, you can see my injuries. If you Google Valerie Houghton sex trafficking, on several websites I posted my injuries and plus her social media posts. I mean, this is all out and open, and the DA is saying, no, she's white. Well, I don't know if that's the reason, but she's connected, but she is white, and he's not gonna prosecute her, but he's gonna go out for all these other gang members who happen to be Latino, and he's gonna prosecute them. But Valerie Houghton, no, she's off limits. And if you think this is just happening to me, you could go to another website, freeariana.org. This other parent who, he caught somebody molesting his daughter. He was soon after, he was prosecuted and assaulted. And Valerie Houghton doesn't deny being involved. I mean, he's lost all the pigmentation in his face. He's turned into a diabetic because he's been poisoned so many times. Go look on his website. You can see the pictures of his injuries as well. I mean, it's terrible what's going on in this county. That
The next speaker is Xavier. Please accept the unmute. You have 2 minutes.
Hello, everybody. My name is Xavier Espana. Just wanted to mention that, I just want to emphasize how deceptive this report is. There isn't any raw numbers, and the fact that the district attorney's office was willing to put this report out kind of shows what the intent of this report really is. I feel it's similar to the fear mongering that the DAs use to push and pass Prop 36. And I think when they listed all the juvenile offenses that they've charged and listed literally every violent penal code that they possibly can, and then say, we believe that 25% of these individuals were either gang-related or gang-associated, but the first line of their report is, it's not illegal to be a gang member. Just shows that they're trying to fear-monger the community to show that there's a high number of criminal activity from gang members, when we know that they're just trying to target Black and brown communities. And I think it shows that, yes, that the district attorney office is willing to charge juveniles as adults and add gang enhancements to increase their penalties, when the district attorney office has opposed 1391 willingly. I think it shows their intent with the report that they want to continue to charge our juveniles with severe sentences. So, yeah, with that, thank you for your time.
Next speaker is Raj. You've got 2 minutes. Please accept the unmute.
Yeah, I want to echo the other public comments that were made that were critical of the DA gang crime report. And I know Deputy DA Stacey Capps mentioned that it wasn't the intention to give the impression that gang charges were being used race neutral, but I can't see how it was done inadvertently. It is the title of the slide on that big screen that says defendants who are white were as likely to be charged with a gang crime. So that was the plan. And I think it is misleading to actually make this the story of the analysis. And I want to unpack it a little bit for people that have looked at it just very quickly. It says that they brought gang charges on 29 cases that were referred to them of people of color. And for white people, 33% of those charges that were reviewed became gang charges. So you could walk away from that thinking that gang charges were being applied in a racially blind way, or even that white people were the recipient of gang charges more than people of color. But if you use the raw data, you look at the pools that they're drawing from, if there were 100 people of color and 29% of those cases were gang charges, that'd be 29 individuals charged with gang crimes. And if the pool of white people that were referred for gang charges were 33% of that total pool would be one person. So end of the day, you'd be looking at 29 people of color that are suffering from gang charges and one white person who is suffering from a gang charge. I think they intentionally knew that they could blur the analysis by withholding the raw data. And I would implore the DA's office and this committee to review the raw data so that we could confront the racialized weaponization of that charge against communities of color in Senate.
Next speaker is Annalisa Zamora. Please accept the unmute. You have 2 minutes.
Good morning. My name is Annalisa Zamora, and I'm with Sister Warriors Freedom Coalition. I want to echo the gratitude that I have for my comrades at Silicon Valley Debug and those the other folks who spoke up today. I'm speaking in response to item 6. The report is deeply misleading and harmful. The claim that white individuals are just as likely of color as people of color to face gang charges is simply not backed by evidence. In fact, local analysis shows that over 98% of gang enhancement convictions in Santa Clara County have targeted Black and brown individuals. If the DA wants to claim race neutrality, then the raw data must be released for public review. The DA's office cannot hide behind the excuse of being colorblind when it is building its prosecutions on top of racially biased policing. The DA doesn't just inherit injustice from law enforcement, it amplifies it. And this report reads like a defense of carceral policies, not a commitment to justice. The claims around increased juvenile gang involvement are unsubstantiated and seem aimed at creating public support for harsher punishments for youth, including rolling back protections under SB 1391. This is not public safety, it's political fear-mongering at the expense of our children. Lastly, assigning police officers to surveil social media under the banner of proactive intervention is coded racial profiling. It drains public funds and further criminalizes communities of color. We demand transparency. Please release the raw data and stop weaponizing fear to justify racist prosecution practices. Thank you.
Next speaker is Raimundo Armendariz. Please accept the unmute. You have 2 minutes.
Good morning, board. My name is Raimundo Armendariz. I'm the executive director of Caras in South County, and I was born and raised in Eastside Gilroy. I did want to also echo and support the position of our comrades at the Silicon Valley Debug and Sister Warriors. We do have concerns about 2 of the items that were listed on the report. One for sure is definitely the claim, unsubstantiated claim of adult gang members orchestrating and influencing younger youth gang members to commit violent crimes. I think there's no evidence. I think it's irresponsible to make that claim without any evidence. I think it's definitely a veiled attempt to push back on reforms and youth justice reforms that have been passed over the last few years, especially considering that gangs, use prisons and jails as an incubator to further expand influence over young people. So I think that it's definitely not constructive. It's not productive to try to send and push back those reforms and send young people back to jail. I think that it actually gives us the opposite effect and increases gang violence by incarcerating young people. So I think that was definitely irresponsible. And of course, the second thing is that the use of the statistic of 33% of gang charges being applied to white perpetrators is definitely an attempt to dispel the reality of racial disparity and disproportionality in the application of gang enhancement laws. Like Raj had mentioned, if you had been more responsible, you would have given the total number of gang charges and gang people perpetrating gang crimes by race and the demographics of those folks, because then you would see that.
Next speaker is Jenny Garcia. Please accept the unmute. You have 2 minutes.
Hi, my name is Jennifer Garcia, and I'm a youth organizer at the Young Women's Freedom Center. I'm here speaking out today because I care about the safety and dignity of our youth. Thank you.
Thank you. Our final speaker is Felicia M. Please accept the unmute. You have 2 minutes.
Hi, my name is Felicia, and I'm a youth fellow at the Young Women's Freedom Center, speaking out because I care about the safety and dignity of our youth. The DA's report makes harmful claims about juvenile gang involvement without any proof. That's dangerous. It's being used to roll back protections like SB 1391 and justify trying kids as adults. This is about fear, not facts, and it puts youth, especially youth of color, at even greater risk of being thrown into the system. We need care, not cages. Many of these youth are growing up in environments where they face systematic poverty, lack of support, and limited opportunities. Labeling and sentencing them more harshly doesn't solve the problem. It only pushes them further into the system. We should be investing in community programs, education, and mental health support, not increasing punishment. Our youth deserve chances, not chains. Thank you.
We have heard from all the speakers that raised their hand before the queue was closed.
Thank you very much. Thank you to all of the speakers who weighed in today. I'm going to start, Stacy, again. Thank you for the report. With some questions regarding the data where it feels slightly incongruent with the narrative. Looking at the first page of the ledge file, I wasn't able to tell from the report, which I believe is the data point on slide 6, if you want to pull that back up, how many total cases were referred to the gang team in 2023 as compared to the same time span in 2024? Because it looks to me like the report's comparing 11 months of data to 15 months of data from January 24th to March, from January 2024 to March 2025, whereas the previous year was January through November. Can you clarify, are we comparing the same data over the same period of time?
Actually, the report was created by the supervisor of the gang unit, and I think you may be correct that he may have included data for a few months longer for this current reporting period than in 2023. I don't think that that's what has resulted in the increase, because he also compared the number that we charged. There was just a dramatic increase from January to March of 2025.
Right, but which certainly may be premature to make
For the entire year of
generalizations about the
2025?
entire year.
Correct.
Yeah, it is challenging if I'm trying to understand trends and looking at different time periods. You also noted verbally in the report that the perception that more juveniles are engaged in gang-related offenses isn't supported by data at this time. I heard your comment. I appreciate that your office and probation are working to gather appropriate data. I would note to debug folks, if you've got your own data set, would love for you to share that so that that can be considered in the review. And just considering the vulnerability of kids, especially black and brown, I really don't want us to publicly put out any information that is prejudicial, that makes presumptions, that is not clearly supported by data, because it just takes so little to send people kind of into fear frenzies, and then I think bad outcomes inevitably and often follow. The report also states that between January and March of this year, the number of cases, you just mentioned that the number of cases charged by the gang team has doubled. Is it a doubling compared to the same time last year, that January to March?
No, that is a doubling from January to March of this year.
Got it.
We didn't compare it to the year previous because I don't think that would be an accurate reflection, because gang crime based on a few months is not reflective of the entire year.
Right. Again, thank you. The data in the report, I'm going to just organize my thoughts and turn to Supervisor Lee, who has his lights on, and then if I have any follow-up, I'll come back again. Thank you. Supervisor Lee.
Yeah, thank you very much. I think this report is helpful, but it actually, to me, presents more questions than answers. And I think many of those has been mentioned by many of the speakers here regarding the conclusion and the data that backs it up. And I would certainly think that this is work in progress, and I think it needs to come back with more numbers for us to better understand how these conclusion is drawn. To make sure that the data matches the conclusion. But first of all, I just do want to say thank you so much for the report. It's been very educational, very enlightening, and many of the questions actually have already been answered to the questions asked by my staff previous to this meeting, so I just first thank you for those. The first question, I think it's been mentioned so many times, is we have the 47,000 plus cases, and only 99 cases were referred for review, and only 51 were charged. So certainly shows that very, very low number of cases was receiving these gang enhancements. So those are very rarely being charged. So that's certainly, that part I think is certainly good news. The part where I think we would need to have some more information is if there's any way we could get the raw data as to the race of those individuals that are in those 47,000 cases to start with, to see how many of those cases versus how many of those 99 cases that were referred to. Those 99 cases, how many of those on the racial data, at least for the 99? Is that something that's available?
So you're asking, of the 99 cases that were referred to the district attorney to
Yes.
charge with a gang enhancement, the racial breakdown of those cases?
Correct, yes.
I think it's possible to do that. I don't know if it's something that we would have to look at each individual case to do that. But I think we could do that, yes.
Yeah, I think that needs to be shown in order to see the percentages that we come to a conclusion. I'm not questioning the conclusion, but for the fact that let's get that data, because once we have that data, what those 99 cases are that's being charged, I think would be helpful. Then we could see based on that and who's being charged to come up with those percentages. Since you're able to come up with percentages, I think the data is there. I think it's just not disclosed here. So if you could provide the 99 cases at least of how many of those charged in terms of racial background, that could be extremely helpful, number one. But of course, for 47,000, there's a far greater number. If we can even have an estimate of those cases on some type of racial breakdown approximately, I think could be helpful. So that's what I'm saying. The other issue that I find interesting, I believe this is page 12 where there's that spreadsheet. The title was Charging Involving Crimes of Violence, which get the, which is that page 12, am I correct?
I'm sorry?
Yes, that's one on the screen right now. Yeah, that's being shown on the big TV here. On that specific chart, one thing a couple of additions I'm going to ask to do. One is fairly easy. Just put the total at the bottom. Is it true that if you add up each of these crimes, like say total offenders charged, like 432, 45, 47, at the very bottom, if you add up, would that be an accurate total if you add all those together? Or it won't be accurate because folks might be charged on multiple charges here?
Again, I'm not sure if this would reflect one defendant being charged with both carjacking and assault likely to commit GBI.
Right.
There's the possibility that that is multiple charges against one individual. I'm not positive on that.
Okay.
And this again is total number of offenders for crimes of violence, not just gang crimes.
No, correct, yes. So the first two columns here are just total charge, nothing to do with gang, just the total charge. The only difference of the first and second columns, the first one is everybody, and then the second column here is just for those under 18 for all these crimes being charged. That's the way I read it, right?
Correct.
All right, so if the total is helpful, I think it'll be good to add it down the bottom if they're not double charged. And if they are, if there's some way we can know what the total numbers are, I think it'd be helpful of how many individuals we're dealing with. One area I'm going to ask is as follows. So the third column, you're able to put out the adults charged by the gang team, right? So that's a separate column, which is certainly very helpful, right, to see compared to the total offenders charged. What would also be very helpful, if I might recommend in the future, will be following. If you could add a column specifically for just non-juveniles or those who are over 18 that's being charged as one column. I think that's fairly easy to do because we have total number and total juveniles. If we can add one just for the non-juveniles as a column, that could be helpful. Second thing I think could be very helpful would be having a column at the very end that says the juveniles charged by the gang team. You following me? And just make sure you're following me. I'm not going too fast here. Because that way, I think you will be able to tell how the charging of juveniles in terms of actual numbers are being presented on this chart. So those are the couple of if you could let us know if this would be accurate and what a total could be put together. So that's one.
Mr. Lee, can I just?
Sure, yeah, please.
Supervisor Lee, can I just respond to that? So most of the cases that are charged for juveniles go to the juvenile team for issuing. The gang team only typically reviews juvenile cases of murder. Those come to the gang team for charging purposes. So I can add that column, but won't necessarily be the gang team that's reviewing a majority of the juvenile cases.
Right.
Okay.
Right, got it. Now, on the next slide, it says that juvenile gang involvement. It identified that from January 1st, 23 to 12/31/23, 251 juveniles were referred to a juvenile probation department for all these different crimes. When you say referred, does that mean charged?
No.
No, okay. So after they're being referred, they are being, reviewed, whether they are worth to be charged, and then a subset of those would actually be charged. That's correct, yes?
Based on the nature of the charges that we were looking at, I would assume a large majority of these were charged.
Okay, all right. So, because what I tried to do is as follows. So on the early chart we have on page 12, under juvenile charged, those numbers, 30, 289, 4, 263, I just do a quick add right here, which means not very accurate probably. I have a total of 136, assuming that they are not double charged. But if they're double charged, those numbers probably be smaller. So I'm looking at this number, 136, would be a subset of the 251 on the next page. Am I correct?
I'm sorry, I'm not following you.
Okay, so on the chart later, it says 251 juveniles were referred. So out of the 251 that's referred, a portion of those got charged. And that's why I'm trying to refer back to the earlier chart. And you have the column that says juvenile charged of all these different crimes. So when I added all that up, that came up to be 136. So,
Well, first of all, I think this is what, I just want to say that a lot of this report is very different from previous reports based on the direction that I got from the Board of Supervisors at the last
meeting.
meeting.
Yeah.
They really requested for me to do my best to attempt to give them numbers about juvenile gang crime. When consulting with probation over a number of months to try and give the numbers that the Board of Supervisors requested, they only had numbers from 2023. So the chart on 13 is reflective of 2023 numbers.
Correct.
The chart on 12 is a chart created by the District Attorney's Office, which dealt with 2024 up through March of 2025.
Those
So
are
they're
different
not,
period. I
yes,
see.
they're two
Okay,
different
got it.
data points. And again, because I wanted to be responsive to the Board
please.
of Supervisors about the percentage of juvenile crime that we felt was gang-related, I did my best with probation's numbers. This data is from probation on 13 to reflect. The only way that we could do that would to be reflect negative peer association, which probation indicated oftentimes is reflective of gang association.
Okay. Yeah, so I'm just trying to correlate, so I'm glad you clarified that the data is only for different time periods, so maybe in the future we could identify it on the chart to basically just state the timing, where this data comes from, so that way we don't get those apples and oranges mixed up, so thank you. So yeah, if we could add some of those data that we mentioned, I asked for earlier in the future, coming back to us, I think that could be very helpful. One thing I also learned, I guess I did not know about this today, is so when somebody got a gang enhancement charge being filed against their underlying crime, that result in two separate trials. They get tried on the original crime first, and then eventually they get tried again on the gang enhancement separately? Am I?
That was part of the AB 333 change in the law.
I see. Okay, that's very helpful. I see there's the public defender's lights on too. Do you want to add to any of this?
Did you have anything else? I wanted you to finish
Yeah,
first.
I think this is, that was quite a bit I added there. I mean, there's certainly lots of questions, but on this round, let's end it there, and if Damon has something to add, I'd love to hear. Thank you.
Public defender.
Thank you, Chair Ellenberg. And just briefly, Supervisor Lee, to clarify on how that trial works, it's in essence a two-part trial. It's bifurcated, so they do the trial without the enhancement or discussing the enhancement to avoid prejudicing the jury. and then they have a secondary or a second half of the trial if there's a conviction on the gang enhancement. I want to start by thanking Assistant District Attorney Capps. I realize this is a sensitive topic. I think it's a sensitive topic for all the system partners. It's certainly a sensitive topic as well for the community. I have just two observations. And I want to start by saying I actually appreciate that the ledge file, and my comments are going to be really directed towards the written report, led from my opinion with the most important statistic, which relates to the issue of really the size, or relates to defining the size of the issue. 47,000 criminal referrals to the district attorney's office, and less than 1% are referred for issuing or consideration of issuing gang charges. That's 99 referrals out of 47,000 incidences that are coming to their office, and that resulted in only 41, at least, or 51 adult cases. What this tells us is that while this is an important issue, in particular because of the related social issues, it is not the legal criminal crisis justifying an overreaction. So that's the first observation I'd share. The second is, while I think there's been a range of reactions, I choose to believe that there's good intentions of everyone involved in this conversation, even when we disagree about policies and strategies. I say that because I want to place in context why I am sensitive about public reports that create narratives that ultimately can change laws. Many of which are currently being discussed in Sacramento. I'll just cite, I know others have mentioned other laws. AB 22 right now is being considered, I believe, which would reduce the minimum age of charging a youth. Right now you have to be 12 years old or older than 12 years old. They're talking about reducing it to 5-year-olds. And so the narratives we create are very critical. I feel compelled to be vigilant about the treatment of our youth and any policy changes that could impact them, especially knowing that the evidence has consistently proven the consequences disproportionately fall on our Black and brown children. The narrative of adults using juveniles under Section 3A of the ledge file can be used by some to change juvenile laws and shift us from rehabilitation to adult punishment. For that reason, I do believe it's critical to be able to access and the ability for us to scrutinize the evidence of supporting such powerful assertions. The only addition I would add is, Supervisor Lee, I think you requested some breakdown or the raw data behind the race charging. What I might suggest is we have just a slightly increased level of granularity beyond white versus BIPOC and really ask the question. I think we commonly, most of our case management systems at least would characterize white, Black, Latinx, AAPI, and then potentially other BIPOC. I think the other BIPOC category will be significantly small.
No, that's very helpful. Thank you.
But I would suggest that may tell us something I think specifically relevant to the demographic of our local population in the county. Thank you.
Great. Thank you so much.
Do you want to make it? Alternate Public Defender.
Thank you very much. Thank you, Damon. I think those were really great comments. I'd just like to add, too, that first, number one, we in our county, I think I'm very proud of the fact that we don't get led by sort of the emotional rhetoric of the moment. I think that we have created policies and practices that are more consistent with data and are more consistent and reflective of our values as a community and as a county. So that is consistent with Damon's statement. I also want to say that although we very often disagree with the DA's office, this is a moment of inflection where we do have to recognize the progress that we are making. And the data reflects that, as Damon pointed out and as Stacy pointed out in her report. It doesn't mean that there isn't greater work, but I think we do need to reinforce the fact that in this county, we started a long time ago with overcharging gang cases and to the detriment of our communities and our youth. That has changed with the law, but I also do believe that it's because of the discretion that the DA's office is exercising, the information they have at the time. And I also want to recognize that if they miss something in their charging, there are opportunities where our offices, our lawyers and our advocates are providing information to the DA's office to enlighten them and inform them about the charging decisions and allowing for an opportunity to modify their charges. And that is working. And that is an important acknowledgement that we need to recognize. The other thing is that absolutely our youth of color are overrepresented in these charging practices, but we have to acknowledge the context of where that's happening and why it's happening in a broader basis, not just of how they come into our door, but because we are not investing enough in our communities of color. The East Side is still completely underrepresented with providing our youth with pro-social alternatives and greater development in the education system for opportunities for growth. We have to acknowledge, too, that our youth are involved sometimes in our justice system because of the fear. The exact same fear that Ms. Capps was mentioning is oftentimes why they have to often participate in really negative peer associations. So again, let's not lose sight of that, because that's kind of our reality, and sometimes beyond the control of this committee, but it's sort of the context of where we're from. The other big thing that we need to learn from and move on is, yes, this is where we are. Some of these numbers are true. Gang crime is real. The victimization is real. But then now what? And that's what we've done in the past too, which is our numbers look high. This is a number that looks like it's increasing. What are we going to do about it? And if we're focusing on our youth, that's exactly where we need to focus, because that's where we have greater opportunity for intervention.
Thank you very much for the thoughtful comments. We've got 2 more items left. We are pushing the very edge of our agenda. I'm going to ask for the remaining 2 items that we go right to questions without the presentations that I was actually really looking forward to. But I think we have to move through our agenda. I'm going to ask you to make a motion based on the information you want back.
Correct, yeah, so we've talked about a lot. So first, let's make the motion to receive the report and also to ask the report to come back to us. And I guess asking staff, how long will it take to gather some of those data back to us in terms of these ethnic data, or as suggested by acting public defender Silver regarding the breakdown and some of these numbers? Is this something that could come back to us within, 90 days? Whenever you can get back to us. Would that be fair?
Yes.
Yeah, okay. So I just want to say, yeah, let's make that the motion. Anything else that I missed?
Nope.
Okay.
Great, I'm happy to second that. Let's vote.
Sure. And I just want to say one last thing. Is that I'm glad to see that we are, based on the report at least, that we are definitely not overcharging. But I certainly think that these gang enhancement, but I think it's important to have the data to back it up to show that that's what we're doing. And I do want to mention this one point is, whether you're in jail or you're outside, when people feel like in order to be safe to join a gang, the system has failed. So I just want to make that a point that I'm very concerned. All right, and that being said,
Thank you very much. Let's vote, please.
Vice Chairperson Lee?
Yes.
And Chairperson Ellenberg?
Yes.
Thank you. Motion carries.
Item 7 is to receive a report from the Office of the Sheriff regarding relating to the Restorative Services Division. And Dr. Child, I do hate to shortchange you on what was an excellent report, and really want to express appreciation for the tremendous work your team does. I also want to thank you for sharing with my office the survey of 231 incarcerated individuals that your department recently completed to learn more about the experiences of incarcerated parents and what services and supports could better help them support their families. I would certainly recommend that you share that with all board offices. And for purposes of this meeting, I just want to lift up 2 of the findings from your report. First, that 67% of parents seek assistance with communication and bonding with their children, and 48% expressed interest in service or programs that would allow them to spend more time with their children. Having that data made it particularly disappointing to learn about the loss of the in-custody packed parenting classes, which had supported family connection by allowing parents to have more time with their children, as well as that the program provided parenting skills classes and other supports. There are a number of studies, I know you know this, I'm saying this because I want it publicly on the record, a number of studies that have shown that programs that support parents in maintaining positive relationships with their children not only work to reduce recidivism rates of the parent, but also work to break the cycles of incarceration by reducing the likelihood that that child has future justice engagement. And I think the previous item makes a very strong case for continuing to fund this type of program. I think they pay dividends and they provide generational benefits. Can you remind me how much the department had requested for a parenting program?
Sure. We initially requested $300,000 per fiscal year.
And what alternative do you see for the program if we can't get that funding into the final budget?
We have been working closely with SSA to see if we could leverage some of their existing contracts. Part of the review that's happening right now is there language in those current contracts that allow those providers to provide services into custody? And we are hoping to reach out and work with some of the more advanced programs in social work in our local community universities to see if perhaps we can have some interns that can come in and run some programs for us as well.
Thank you for being so creative. This is going to be an impossible and stressful budget period. I think relatively in the budget world at the county, $300,000 is not very much at all, but by the time you add up everybody's preferred programs that are $300,000, $500,000, it really does add up. But I'm going to maintain that investment in prevention, and very early intervention will save us so much money, will create healthier communities, and will reduce a lot of the instances that we've been talking about today. So just want to thank you again very much for the report. I'll turn to my colleague for any questions and then go to the public.
Oh, good. So first of all, thank you so much for the report. I'd like to also spotlight that the lived experience protocol, and really want to thank the sheriff for allowing and granting the access to those with lived experience into our jail. These are really a game-changing type of work that matters, and we've received 2 emails praising this program, and it's a powerful way to ensure that people with lived experience have the real voice here. The FFT recidivism chart on 14 is certainly compelling. As we move forward with these programs, it'll be good to also get this kind of information about all of our programs in the future reports, and this might even help our programs that aren't as effective be beneficial. Thank you so much. That's all I have.
Thank you.
I have a motion to move to receive the report. Thanks.
I'm happy to second that motion. And I see ADA CAP has your light on. Do you have a comment on this item? Nope, no worries. Do we have public speakers?
Yes, we have 2 on Zoom and 1 in chambers.
All right. I'll make a quick last call. And if there are no changes, we'll close the queue at 3 speakers, 2 minutes each. Thank you.
Okay, we'll begin with our in-person speakers. Paul Soto, if you could please approach the podium. Looks like he's no longer with us. We will move on to our Zoom speakers. Parent, I am unmuting you. Please accept the unmute. You have 2 minutes to speak.
Yes, I'm so glad that our restorative programs, our justice programs are trying to assist parents. But one thing we have to be mindful of is the abuse of this program. That's because my kids are being sexually molested, and the charges were brought against me they wanted to quickly move the matter to competency proceedings and discredit everything that I said. And this is the district attorney's office who raised the doubt, even though they had evidence that my youngest daughter was in the custody of a man who previously drugged and raped a teen, and they knew that was my child, and they said, he's crazy because that's not his child. And they had evidence to the contrary. They knew about the rape, but they brought the matter to competency proceedings to absolve Valerie Houghton of her crimes. And let me tell you that Valerie Houghton has done this to other parents. if you look up a case, Jamie Terpko, Terpko, her child independently brought up to the school that that she was being molested, and Valerie Houghton made sure to cut off that parent from the protected parent from the child's life, and then she wanted the protected parent to undergo a psychological evaluation, and that parent wisely declined. And if you look up also Violet Brooks, who Valerie Houghton was involved with, her 3 girls were molested until they were 18 because Valerie Houghton was involved, and nobody did anything to stop the abuse. And it's really shameful what's going on in this county, that we're using our justice system against the community and covering up the sexual crimes against children. It's just disgusting what this county's doing, especially to my kids, that you guys are listening to me and not doing anything. Thank you for your...
Before we hear our final speaker, I'm going to look to County Council Kavita Narayan to request some guidance, beginning with the next meeting, on assuring that public comments are directly related to the item on the agenda. There is a public comment period at the beginning of each meeting for items not on the agenda, and I want to be sure I'm respecting public commenters and making sure that we're respecting the time of the committee members as well.
Absolutely. Would you like some guidance to be discussed at the beginning of the next meeting, or to talk about that offline?
Let's talk offline and then make the decision about the beginning of the next meeting.
Great.
Thank you very much. And thank you for your patience. Go ahead with the final speaker.
That was our final speaker. The other dropped off the call.
Okay. Thank you. Item 8 is to receive a report from the Office of the County Exec relating to the Community Engagement Plan for the first phase of the jail.
Have we taken a vote on 7?
Did we vote on 7? We probably didn't.
We had a motion, but no
Motion
votes.
second.
Yes.
Yes, and the
Vice Chair-
vote is aye.
And yes. Thank you
Okay,
very
thank
much.
you.
Thank you, Supervisor Lee.
Thank you.
What did I just say? Community,
8.
Thank you, Consuelo. Hi. And again, thank you very much for the report and the really thoughtful integration of the feedback that you received from the board, as well as members of the public. I just appreciate that very much. I want to take this last minute while we're here to really highlight the importance of the ATI integration into this work, and why I view it as so integral to conversations around new infrastructure. Prior to any discussion of best practices around design of our new jail, there are going to be 2 community engagement sessions and multiple focus group meetings that will center on the current custodial population projections and ATI efforts to further reduce our current and projected custody population. And I think those discussions are going to be critical to implementing actions that could safely divert people from incarceration or reduce the need in the first place, which will, of course, dramatically impact the right sizing of whatever facility we end up needing to build. So I just wanted to draw attention to that, because I've received questions about why we're talking about alternatives to incarceration in the same bubble in which we're talking about building a new carceral facility. It's not quite as incongruent as it sounds. So thank you again for the report, Supervisor Lee.
No further comments. I'm ready to move to receive report.
All right, I'm happy to second that. Looking up and down for lights. Do we have public speakers on this item related to the jail?
We had one request to speak in chambers from Paul Soto, but I believe he has left.
Okay. All right, then let's vote, please.
Vice Chairperson Lee?
Aye.
And Chairperson Ellenberg?
Yes.
Thank you. Motion carries.
Thank you. Item 9 is our opportunity for PSJC departments or the court announcements. Do any folks up on the dais have announcements? You're pointing, but I don't see where you're pointing. Oh, Public Defender.
I was pointing to Director Aguirre because together, along with, I think, probation and the district attorney's office, We are collectively hosting a community resource fair and pop-up court on May 16th at the Alma Community Center, so over in our East Side community. And there will be all kinds of services, including warrant recalls, record clearances, fine and fee waivers, record reductions, et cetera. So please come. I would encourage the community or anyone in Chambers to come join us on that particular day. And actually, I can acknowledge Judge Gaffon, who helped us with our last pop-up court down in South County. So thank you, Judge.
Wonderful. Thank you. Deputy Probation Chief.
Hey, thank you. Yeah, in the spirit of that, also last Wednesday we had a second chance employment resource fair at APD. I just want to give you some quick highlights. We had over 278 participants there, 11 on-site employers, 22 resource partners, 10 county agencies, 5 clients got hired on the spot. The county clerk's recorder's office provided 15 free birth certificates right there on the spot. And we unveiled our new a soft launch of our probation mobile unit, and we had like 50 contacts right then and there with that unit. It was a soft launch. So it was a really, really good event, and we appreciate all the partners that had like-mindedness and seeing our community partners like that. So we really had a really good time, and we look forward to a lot more of them.
That's awesome. Thank you very much. Javier?
Yes, on Friday, we'll be hosting a graduation for our Challenge Accepted High School program. So we're looking to graduate 15 individuals in partnership with County Office of Ed. And then on the 21st, we'll have a graduation with our Drug and Alcohol Peer Mentor class with San Jose City College. So we're really excited about May is graduation, promotion, and all those various celebrations. And we look forward to supporting our families and our clients in these recognition days. Thank you.
Love that. Thank you. Greta?
I just wanted to thank Judge Gaffon and Judge Emity for co-hosting many of the justice partners at a meeting that occurred, I believe, last week, and for their engagement and ongoing work that we've mentioned a few times at this committee related to really looking for opportunities for us to collectively implement some of the more challenging components of justice reform that really require multiple justice partners to closely collaborate. Really also wanted to highlight and appreciate some of the court's current and then also future-looking efforts to really try and improve certain efficiencies as the county and the court face really significant budgetary challenges. I think we've identified many and will collectively identify many more opportunities where efficiencies in the court process really translate into opportunities to better utilize the resources of county justice partners while also really ensuring a continued focus on appropriate resources, appropriate process for all criminal justice proceedings. So look forward to continued progress on that front that we hope to report out at future public safety and justice meetings.
Thank you. Judge Gaffon?
Thank you. I just wanted to reiterate that. I agree. We had a great lunch. We're looking forward to further meetings, and I know that's going to be set up in the near future. I was just speaking with Judge Emity about that yesterday. And I also wanted to announce that we're happy that the governor gave us a new judge yesterday. Christopher Van Meer, who's coming to us from the Public Defender's Office, was appointed. And we're looking to get him started as soon as possible. Hopefully we'll be getting some more appointments. We still have many openings on the bench right now, and we're hoping to have new colleagues moving forward in the next few months. So thank you for that.
Also wonderful news. Thank you. Our next meeting, regular meeting of this committee, is June 25th, and that will include a study session on strategies to reduce the jail population, including the possibility of reinstating a $0 bail schedule locally. I want to thank DBUG for their statewide efforts to promote $0 bail, and I encourage anyone who is interested in that topic to join us on June 25th at 10 a.m., and we are adjourned.